All right, so Kentucky Study students, what we're going to focus our attention on over the next 2 weeks is the politics that are involved in Kentucky and the structure of our government in Kentucky and what is in the state constitution. Because there's a lot of people in Kentucky that kind of casually follow what our national or what our state government does, but they don't really understand it. And so hopefully by the next 2 weeks, one will get in person and one that will do asynchronously, you'll kind of have a better understanding of how the Kentucky constitutional structure operates and how it functions. These particular notes are going to talk about Kentucky's constitutional history, how our state constitution has evolved, and what changes have taken place in the 20th and 21st centuries to bring the document more up to date with modern times. As always, you want to make sure you take notes on this particular presentation. These are our third notes, so they can go with your first and second notes that we've had here in this course. And these notes will help you out as we get to the unit exam at the end of next week. So let's talk about, first of all, the big ideas about Kentucky's Constitution, some of its origins, and just some general information to know. First of all, understand that state constitutions exist throughout the country. Each state in the United States is required to have a constitution. Kentucky is no different. However, understand that the national constitution that belongs to the U.S. government does have supremacy over the Kentucky Constitution. However, in terms of how the government operates and how it functions, the state constitution is vital and it's very important. Now, the one thing that you want to also recognize is that state constitutions and constitutions in general mirror the times in which they were written. For example, in the U.S. Constitution, in the Seventh Amendment, our Bill of Rights, it specifies that if you sue somebody for more than $20, then you can get a jury trial. But $20 back in 1787 was worth a lot more than $20 is today. However, in Kentucky, our state constitutions have evolved over time, but as they've evolved, they also still reflect the background of the times in which they were written. So do not forget that big fundamental idea as we talk about the different incarnations of the Constitution. And do recognize that Kentucky has had multiple constitutions since 1792. In fact, we have had 4 different constitutions in our state's history, which is a lot different than other states who have sometimes gone through fewer or more constitutional revisions, and it is much more than the national government that has not had a new constitution since 1787. So let's talk about what these different constitutions did in summary and some of the major changes that were brought about. Now, the first Constitution was written in 1792, the year that Kentucky became a state. We became the 15th state in the United States, just behind Vermont and the other 13 states that were part of the original 13 colonies. The original state constitution in Kentucky was very liberal. We had very liberal voting rights for the time period because we allowed more people to vote than any other state. And that was simply because all free white men that came to Kentucky, it didn't matter if you had property, it didn't matter your religion, it didn't matter your political leanings, you earned the right to vote merely by being a resident of the Commonwealth of Kentucky. And some of these very liberal voting rights are what brought a lot of people into Kentucky after 1792 because they couldn't vote in their home states for a variety of reasons. They didn't own enough property, they were Catholic, they belonged to another religious denomination, they didn't contribute to the state-sponsored church, whatever have you. And in fact, Kentucky took religious freedom very seriously. If you look at our Bill of Rights and the Kentucky Constitution, it is a lot more detailed on the principle of freedom of religion than you will find in the national document. But as long as you were a white man over the age of 21, you could vote. And we also created some provisions there to limit the power of voters, even though we gave the right to vote. For example, our first governor of Kentucky was Isaac Shelby. His picture is right here in the presentation. He was a Revolutionary War veteran. He was very important in fighting the British and the Native Americans here in Kentucky. But he was not chosen directly by voters. Voters did not directly vote for Isaac Shelby in the 1792 gubernatorial elections in Kentucky. Instead, it was chosen by a college of electors. And if that title sounds familiar, remember that we have an electoral college in the United States where indirect representatives cast their ballots for the presidency of the United States. So at the time that Kentucky's first constitution was established, there was a college of electors that chose the governor and the state senators, not the voters directly. In 1799, Kentucky got a new constitution. This revised some of the lagging gaps in the first document in 1792, And by the way, our first Constitution was agreed to at Danville, which isn't too far from here, my hometown. But the new Constitution in 1799 got rid of that College of Electors idea and allowed for the voters to directly vote on the ballot by name their governor and their state senators. So this allowed there to be a more direct process through which voters could let their feelings be felt. Also, a new office was created underneath the governor, the position of lieutenant governor. This position was basically the vice president of Kentucky, and that at the time, if the governor was away at another state or the governor was incapacitated, the lieutenant governor would take over. That office still exists today, although many of its powers have been reduced. But at this time, the lieutenant governor was the governor in waiting of our existing governor in the Commonwealth of Kentucky. And so the 1799 Constitution simply got rid of that College of Electors, and it also restricted some of the governor's power because the original Constitution allowed the governor to appoint local officials. And so this took that power away so that local democracy could function and local people could better pick their local leaders without interference from the state governor. In 1850, there was a major national debate over the topic of slavery. Remember, Kentucky was a slave state, even though we did not fight with the Confederacy in the American Civil War. And the state constitution in 1850 reflected this national debate on the slave debate, and it issued a lot more protections for slave owners in the state to maintain control of their slaves and gave them a lot of leeway to do so. In addition to that, if an owner made the choice to free their slaves, those newly emancipated slaves had to pick up and leave for another state. Freed blacks were not allowed to live in the Commonwealth of Kentucky between the 1850 Constitution through the American Civil War. And the principle behind that was the fear that emancipated slaves would try to stir other slaves into rebellion and create issues for state security. And Kentucky was not the only state that did not allow freed blacks to reside. Indiana was another one. And so this created a lot of hardship for those that had previously been slaves that were freed, but then they had to pack up and leave their families and the state that they once knew. But that was the Constitution 1850, and it reflected the fact that Kentucky was a slave state. In 1891, Kentucky passed its fourth and final constitution, the constitution that we still have with us today, because Kentuckians have been more politically polarized since 1891, and proposals to have a new constitutional convention have been shot down. But in 1891, Kentucky was a more rural state than it was today. We've talked about the urban versus rural divide. And Kentucky is still largely a rural state, but it was even a more rural state in 1891. And by principle, rural areas tend to be very distrustful of central authority, largely because people feel that central authority will try to interfere in their ways of life or make their farming lives a lot more difficult. And so our state constitution issued a lot of restrictions on what the government could do. For example, the governor was not allowed to run for re-election. The state legislature was only able to meet once every 2 years and for a very limited amount of time. And there were other parts of that constitution that issued a lot of restrictions on government. And nowhere is this made clearer than the fact that Kentucky's constitution in 1891 has 260 sections in it versus 24 for the national government. Because the national constitution tends to be very broad. It tends to be, very open in terms of how it can be interpreted. But Kentucky's constitution, like many state constitutions, is very specific. And because of that, we have a lot more limitations on government than you can find at the national level. So Kentucky's been through 4 constitutions, but all of them kind of reflect the changing dynamics of their times, establishing a new state, making modifications, the slave debate within the Civil War, and then finally the more rural population of Kentucky in 1891. However, there have been ways to change the Constitution since 1891 without changing the entire document, and this is part of the amendment process. Just like people can amend or change the national Constitution, we can change the Kentucky Constitution as well. And the process to change the Kentucky Constitution is as follows. An amendment proposal is given out in the Kentucky House of Representatives, in the State Representatives House, and in the State Senate. And if 60% of each chamber vote in favor of the amendment, it is then put before voters at the next election. And if a majority of Kentuckians vote yes on the amendment, it is made part of the state constitution, so long as that amendment doesn't violate the existing principles of the Constitution. So Kentucky's interesting in this way because we allow the people to have a direct vote on whether amendments go into the state constitution or not. And since 1891, Kentuckians have made a variety of changes and approved of changes to the document. One of them was a reorganization of the Kentucky judiciary, and we'll talk about this in our next notes. But in 1975, there was the creation of the Kentucky Supreme Court, made of 7 justices that serve 8-year terms, and these justices are elected by Kentucky voters. Also, we mandated that to be a justice, you had to have been an attorney with previous legal experience, as prior to this, there were judges in Kentucky that didn't have legal experience. And also, it reduced the number of courts in Kentucky from 1,000 to about 200. So we had a major legal shakeup in Kentucky as part of the 1975 amendments that voters approved of. Also in 1992, we changed that old provision in the Constitution that did not allow governors to run for re-election. Governors are now allowed to run for re-election one time. And so, for example, our current governor, Andy Beshear, his term of office will expire in 2023. If he opts to run in 2023 for re-election, he can do so. However, if he were to win that election, he could not run again in 2027, although the provisions of the Constitution would allow him to run again in 2031. So governors can't serve more than 2 terms consecutively, but they could take a term off and then come back and serve some more. And the idea behind this is that it will allow governors to get more of their agenda passed and be more powerful leaders in the Commonwealth. And voters accepted that change in 1992. We also got rid of racially biased language in our state constitution in 1996. And some of this racially biased language had some derogatory terms for African Americans in the document. It also made some pretentious wording with colored schools, which was the term that was utilized at that time in state law as part of the Jim Crow setup for Kentucky schools that was struck down by Brown v. Board of Education. But sadly, when this went before voters, it was only passed by about 62% or so of voters. More than 30% of Kentuckians did not want to eliminate that language in our document, which sadly shows some of the biases that exist in Kentucky at the national level and some of the racial antagonisms of Kentucky are still there below the surface. But nevertheless, that language was thankfully stricken from the Constitution in 1996, and it no longer exists. And Kentucky is also looking at some future changes to our Constitution. One provision that we're thinking of putting in is based on Megan's Law, this idea that if a criminal is released, that the victims' families are notified. And it also is being debated right now about whether the governor, when they run for office, should have to name their lieutenant governor in the primary when they run for election like they do now, or if they should have to name their lieutenant governor choice after the primary. So those changes are kind of gradually working their way through the system, and voters will have to decide on those in future elections. So when you go to the ballot box, do not be surprised if you remain in this state if you have to vote on future constitutional amendments, because those things are pretty vital. So now that you've finished this, what you want to move along is to the third step of our module, which is the preamble versus in the state constitution versus the preamble in the U.S. Constitution. And what you're going to be doing is just looking at the comparison of the language in those documents and how does Kentucky's preamble compare with the national one, and what principles do you see there in the Kentucky preamble, or basically the introduction to our state constitution. If you have any questions, email is the best way to reach me, but otherwise I hope everyone has a great week.